Hi, this is David Barnett from Barnett Lerner and Carson, PA. Oftentimes, clients ask questions as to what transpires if we're unable to get issues administratively resolved before the U.S. Department of Labor. If cases become disputed where the insurance carrier is denying certain benefits, oftentimes we have to have the case referred to the Office of Administrative Law Judges. In order to start that process, we'll typically have to file a form called an LS-18. This is known as a pre-hearing statement. That form is first sent to the U.S. Department of Labor, who then will thereafter forward the case to the Office of Administrative Law Judges. Typically, a notice from the Department of Labor to the Office of Administrative Law Judges is forwarded to all parties, so you may receive a letter indicating that the case has now been transferred to Washington, D.C. Once the case gets to Washington, D.C., that's the office where the chief judge overseeing all trial judges that litigate or oversee Defense-Based Act claims basically works. There are offices throughout the United States that have various different administrative law judges that work in these offices, but most of the judges travel around the country to attend trials. What basically transpires is the chief judge will thereafter assign the case to a trial judge who will thereafter schedule trial. Trials are typically held within 75 miles of a claimant's residence. If that is inconvenient, the parties oftentimes will agree to a different location so that the case can be heard on a more expedited basis. In order to prepare the case for trial, your lawyers will get involved in discovery, they'll take depositions, they'll meet with you, they'll gather all the medical records, they'll gather the wage records. They'll gather all the evidence necessary to prove your case and establish your entitlement to the benefits that are currently in dispute. The court will ultimately provide all the parties with a notice of hearing, a location, and a time. Typically, it takes about 6 months to 8 months before we get notices of a hearing to proceed with your trial. And it's your attorney's responsibility in that time frame to make sure that all the evidence is gathered and the case is properly prepared. Typically, when a case goes to trial, it's a non-jury trial, so the only people that will be there will be yourself, your attorney, the insurance company's attorneys, whatever live witnesses, and the judge. It typically can take place in a courtroom, a conference room, or wherever the court finds an appropriate place in order to go over the documentary evidence. Oftentimes, the evidence is submitted both on the record as well as verbal testimony. But when you go to trial, typically the courts have not reviewed some of the documentary evidence, so don't expect a ruling at the time of trial. Typically what will happen is a judge will, after trial, review all the documents and require the lawyers to prepare a written brief or a written statement as to why they each win. That'll then go to the court will then review that, and at some point thereafter an order will be entered ruling on your case. Typically, in my experience, having done this for well over 22 years now, the insurance company and the lawyers brief their cases, but the courts can take a long time to ultimately rule. I've seen rulings ranging anywhere from a few months to almost 2 years for a court to rule. Unfortunately, in the time frame that we're waiting for the court to rule, there's not much that can be done other than just wait for the court's ruling and hope for the best. If you have any questions or we can help you with any concerns you may have regarding litigation of a claim, feel free to contact us at Barnett & Lerner, PA, or by our website or by our email address. Thanks.